Hey there, it's Anonymous Tea, where we spill the tea anonymously. Hello, everyone. Hello, YouTubers. Hope you guys are all having an amazing day today, sending good vibes, sending positivity, sending blessings, and good energy to each and every single one of you. Thank you so much for tuning in. So, anything I say is alleged and in my very, very personal opinion. This is for entertainment purposes only. None of this is personal. The Copyright Act of 1976 is in the description box. Some meat and potatoes, some housekeeping items. It is free to follow me. Free to follow me on this channel, Anonymous Tea. Free to follow me on my other channel, Anonymous Tea Podcast. There is new content over there. Follow me on the Tickety Talk at Anonymous Tea Podcast. Free to follow me on the Instagram. On the Instagram is at Anonymous Reality Tea. Free to share everywhere. Free to like the video so it gets out to the algorithm. Free to share with your family, your friends, and your foes, and coming or going, hit the like button. So today we are talking Real Housewives of Atlanta, and we're talking this Kandi Burruss and Todd Tucker divorce, you guys. Where are the Bravo cameras, you guys? Because this, like I said, was bound to be messy. This was bound to be a disaster, and now everything has gone up in flames, you guys. What am I talking about? What has happened, you guys? Before we get into this court document show. Apparently, allegedly, and I saw this on Michelle Atalian's page first. So, you know, we have the response from Todd, right? I did not know that Kandi went right to the court today and also filed a response to Todd's response with her own claims, her own requests as well, you guys. This is going to be a battle royale, you guys. And also, there is a request in a date in January, a hearing in January to seal these documents. No. Why do we need it sealed? Why do we need it sealed? This is given Drew Sidora. This is given back with Phaedra Parks. No. Why do we need this sealed? But here's the thing, too. Those of y'all who, you know, watch Love Marriage Huntsville, even if something is sealed or not sealed, sometimes allegedly these cast members, these people will send you the documents anyways. But nonetheless, let's get into it. So first we're going to talk about Todd Tucker's response, and then we're going to get into Kandi's response, right? So it says the following, you guys, and again, they are still, you know, obviously since the original filing does not, has their first name, initial, and of course their full middle name and last name and everything else, that is what we are continuing with. So it says answer and counterclaim for divorce and other relief comes now, respondent T. Jermaine Tucker, and by through his counsel of record. You guys, I have been manifesting this. Randy M. Kessler. Randall Kessler. Randy Kessler is Todd's attorney, you guys. And Asha Hayward James of Kessler and Soleimani, sorry if I'm saying your last name wrong, and files his answer and counterclaim for divorce and other relief. Respondent T. Jermaine Tucker, husband, and petitioner K. Lanice Tucker, wife, were married on April 4th, 2014. On that same day, a purported prenuptial agreement prepared by wife's attorney was presented to the husband without the husband having counsel, even though the wife's counsel had communicated previously with the undersigned regarding a potential prenuptial agreement. The minor children are currently in the husband's care and residing with him in Georgia, while wife's out-of-town state work obligations have required and will continue to require her to be away from the children for at least the next several months. No. I think this is in reference to the play that she's got on Broadway. The parties have been working cooperatively in an effort to resolve all issues, and husband remains committed to continuing those discussions in due faith. However, in the hopefully unlikely event the parties are unable to reach a full agreement, husband shows that he will seek an award of primary physical custody, joint legal custody, and final decision-making authority, with wife having substantial time and meaningful access to the children. Husband wishes to make it clear that he recognizes wife as a loving and capable parent. Yeah, because he's not trying to say nobody's no deadbeat out here or that they're unfit, and remains sincerely hopeful that prior and continued discussions between the parties will bring full resolution of all matters. First defense, husband affirmatively shows that the petitioner's petition for divorce petition is procedurally deficient. Ooh, not deficient. Under OCGA 19-5-5, specifically, petitioner failed to verify petition as required by subsection A -2, state the residence or last known address of respondent as required by subsection B 1 and 3, provide the name and age of each minor children as required by subsection by 4. Husband reserves all right to challenge the sufficiency of the petition based upon these statutory deficiencies. No. Response to petition for divorce. Husband admits the allegations contained in paragraph 1 of the petition. 2. Husband admits the allegations contained in paragraph 2 of the petition. By way of further answer, husband likely has or will execute an acknowledgement of service. 3. Husband admits the allegations contained in paragraph 3 of the petition. By way of further response, husband shows that the parties were married on April 4th, 2014. Husband neither admits nor denies the allegations contained in paragraph 4 of the petition. Husband admits that 5. Husband admits the allegations contained in paragraph 5 of the petition. 6. Husband admits the allegations contained in paragraph 6 of the petition. 7. The allegations contained in paragraph 7 of the petition require no response from husband as it contains petitioner's request for relief. To the extent that a response is required, husband admits in part the allegations contained in paragraph 7 of the petition to the extent that the minor children have been in custody and joint control of both parties. 8. The allegations contained in paragraph 8 of the petition require no response from the husband as it contains petitioner request for relief to the extent that a response is required. Husband admits that in the best interest of the minor children for the parties to be awarded joint legal custody of minor children. 9. Husband admits the allegation contained in paragraph 9 of the petition. 10. The allegations contained in paragraph 10 of the petition require no response from the husband as it contains petitioner's request for relief. To the extent that a response is required, husband admits in part that the party signed a prenuptial agreement dated April 4th, 2014. By way of further response, husband directs the court to husband's counterclaim for divorce and other relief for husband's further response to the allegations contained in paragraph 10, which the response is incorporated herein. 11. The allegations contained in paragraph 11 of the petition require no response from husband as it contains the petitioner's request for relief. 12. The allegations contained in paragraph 12 of the petition require no response from the husband as it contains the petitioner's request for relief. 13. The allegations contained in paragraph 13 of the petition require no response from the husband as it contains petitioner's request for relief. 14. Any allegations not specifically admitted to herein denied. Wherefore, husband prays that any prayers for relief enumerated in the petition be denied to the extent that they conflict with the relief sought by the husband. Counterclaim for divorce and other relief. Comes now, T. Jermaine Trucker, respondent husband, and by through undersigned counsel, files his counterclaim for divorce and other relief, respectfully showing the court as follows. 15. Husband is and has been a resident of Fulton County, state of Georgia for 6 months prior to the date of the filing of this counterclaim for divorce and other relief. 16. Petitioner is a resident of Fulton County, state Georgia, not state of Georgia, by virtue of the above stated complaint, wife is subjected to the jurisdiction and venue of this court. 17. The parties were lawfully married on or around April 4th, 2014, and are currently living in a bona fide state of separation. 18. There are 2 minor children born as issues of this marriage. Of course, we know the kids' names and the date of birth and all of that. 19. The husband shows that he should be awarded temporary and permanent legal custody of the parties' children as well as financial decision-making authority. No. 20. Husband shows that he should be awarded temporary and permanent primary physical custody of the children. In the event the parties are unable to resolve issues privately, the court should determine all matters related to the minor children in accordance with OCGA 19-9-3 and 19-6-4. 2015. In accordance with OCGA 19-9-69, husband shows the following. The minor children have resided with the parties at the marital residence, and it has that address, you guys, since birth. Husband has not participated as a party or witness in any other capacity in any other litigation concerning custody of the parties' minor children in this or any other state. Husband has no information concerning custody or other custody proceedings concerning the minor children presently pending any other court in this or any other state, and husband knows no person, no party to this proceeding who has physical custody of the minor children or claims to have custody or visitation rights with respect to said minor children. 22, in the event the parties are unable to resolve these issues at mediation or otherwise, husband requests that these issues be heard at the 30-day status conference scheduled for January 12th, 2026, or the alternative that this matter be scheduled for a temporary hearing at the court's earliest convenience to address temporary custody, parenting time, and all other temporary issues necessary to promote the best interests of the minor children and ensure clarity and stability for the parties pending final resolution of this action. 23, husband is entitled to a divorce from petitioner on the ground that the marriage is irretrievably broken as defined in OCGA's 19-5-3, 13, and there are no prospects for reconciliation. Husband is further entitled to a total divorce or a divorce vinculo matrimony, while husband remains hopeful that the parties resolve all issues amicably and privately. Husband expressed reserves the right to assert and additional grounds for divorce permitted by law. Husband shows that the parties signed a prenuptial agreement dated April 4th, 2014, immediately prior to the wedding ceremony. Petitioner's counsel at that time was fully aware that husband was represented by the undersigned and had been actively communicating with his attorney regarding the terms of the potential prenuptial agreement. Despite that knowledge, petitioner's counsel presented the final agreement to husband for signature immediately before the wedding ceremony without any notice or consultation with the undersigned counsel who had been significantly engaged in the negotiation process. No. These circumstances raise substantial questions concerning the enforceability of said document. Nevertheless, the husband remains committed to working in good faith to resolve this matter amicably and privately to the extent possible. During the course of the marriage, the parties have acquired various assets, known and unknown to husband, intangible and intangible. Husband should be awarded equitable division of all marital assets, both real and personal, tangible and intangible, between the parties. Husband shows the court that he should be awarded his separate property and any appreciation thereon. Husband also shows that parties have acquired debt throughout the course of the marriage. Husband requests that such debt be equitably divided. Husband shows that OCGA 19-5-7 provides as follows with regard to the transferring or disposition of party. After petition for divorce has been filed, no transfer of party by either party except for a bona fide transfer of payment of pre-existing debts shall pass title so as to avoid the vesting thereof according to the final verdict of the jury in the case. 29. Further, wives bound by the provisions of OCGA's 19-6-1, which provide as follows with respect to the transferring or disposition of property. Pending the final determination of the court of the right of either party to alimony, neither party shall make any substantial change in the assets of the party's estate, except for in the course of ordinary business affairs, except for bona fide transfers for value. Husband insists that the petitioner comply with the foregoing statute in all respects. Petitioner is put on notice to not only the law of the state of Georgia, but also on notice of husband's intent to insist on full and absolute complete compliance of petitioner. 31. Husband hereby places petitioner on notice of the following important provision regarding the spoliation of evidence. You are hereby notified that Georgia law requires you to exercise reasonable care to protect and preserve evidence relevant to the issues of this case in action. By notice, you are hereby given notice not to destroy, conceal, or alter any video, audio, paper, electronic files, other data in connection with this pending litigation, including but not limited to any of the following following items that are either present in your possession or control, which may come into your possession while this case is ongoing. Any financial records or statements, all income records, all tax records, all expense records, all recordings or evidence reflecting relevant conduct by either party, any item that supports any defense raised by you, this petition, and or any item that supports any claim made by you, any counterclaim or pleading filed in this matter, you are further notified that a failure to comply with this notice may result in sanctions for any destruction of failures to preserve any final judgment and decree of divorce, and that the husband should be awarded such other and further relief as this court deems equitable. It's respectfully submitted on the 26th day of November 2025, you guys. And so then we now got to get to Kandi's answer, you guys. We have got to get to Kandi's answer and everything else. So then you guys as well. Oh my gosh. Whew. Amended petition for divorce. Comes now the petitioner, Kandi Lenise Tucker, hereinafter petitioner, and files her amended petition for divorce against respondent T. Jermaine Tucker, hereinafter respondent, and shows the court as follows. Petitioner filed for petition for divorce before Fulton County Superior Court on November 21st, 2025. Petitioner served counsel for the respondent on the same date. Respondent is a resident of Fulton County, Georgia, and is subject to the venue and jurisdiction of this court. Personal service may be effectuated upon the respondent and his current residence in Fulton County, Georgia. Petitioner reserves the right to amend her petition and other relevant pleadings with the physical address of the parties for safety concerns. Petitioner and respondent were married on April 2014. Prior to the date of the marriage and the conduction of the marriage ceremony, the parties that drafted, negotiated, and executed an enforceable prenuptial agreement under the applicable statuses of the state of Georgia. Attorney Randall Kessler represented the respondent, and he provided legal counsel and direction to the respondent during these considerations on and off camera. Further, the parties' journey to executing an enforceable prenuptial agreement was filed and broadcasted on Bravo television network with the knowledge and consent of both the petitioner and the respondent for their 5-part reality television wedding documentary entitled Kandi's Wedding that premiered on June 1st, 2014, which is giving evidence, which is giving exhibit A, B, C, D, E, F, G. And the respondent audibly announced during this documentary that he was indeed, quote, good to sign the prenuptial agreement during a private encounter with the petitioner after consulting with his attorney, Randall Kessler, on and off camera. There are 2 minor children born as issue of marriage between the 2 parties. It has, of course, the children's names and the years of their date of birth and all of that. And the minor children has resided with the parties since their birth to date. Both the petitioner and the respondent are public figures and self-employed entrepreneurs who work in the metropolitan area and throughout the United States. During the periods of time that the respective parties' work schedules required them to travel, the petitioner has hired and paid the expenses for a full-time nanny. So what about daddy daycare? No. The nanny has provided care and assisted with the parties and the minor children throughout the marriage and has since their respective births of each of the minor children to the date without any objection from the respondent. Both the petitioner and the respondent have held professional obligations that have required each party to travel away from the home for extended periods of time, independently and jointly, prior to and after the births of both of the minor children. In addition to the nanny service, the petitioner has a diverse and concentrated family support network, which includes maternal grandparents, aunts, uncles, and cousins within a 5 to 20 mile radius of the family residence. The petitioner support network is readily available and has traditionally supported the minor children emotionally and physically throughout the marriage in accordance with the petitioner. Therefore, the petitioner amends her petition and asserts in accordance with OCGA 19-9-3 that it is in the best interest of the minor children for her to be awarded primary physical custody of the minor children, with the respondent being awarded parenting time with the children on a consistent basis in accordance with parenting plan. So Kandi went from filing joint custody to Todd filing for sole custody to now Kandi coming back and saying, no, you can't daddy daycare me. I'm going to file for primary custody as well. No, and you need a parenting plan. The petitioner reaffirms that it is in the best interest of the minor children for the parties to be awarded joint legal custody of the minor children, and further asserts that it is in the best interest of the children for her to be awarded final decision-making authority with matters related to academics, education, and healthcare. Wherefore, petitioner prays that A, she is awarded total divorce from respondent, B, that the petitioner is awarded joint legal custody of the parties' minor children with final decision-making authority with matters addressing academics, education, and healthcare on a temporary and permanent basis, that the petitioner is awarded primary custody of the minor children on a temporary and permanent basis, that the parties' child support obligations be determined by the child support guidelines in the state of Georgia, that the prenuptial agreement is enforced on behalf of the petitioner and the respondent, and that the petitioner is granted any and other such further relief as the court deems equitable or appropriate on this first day of December 2025, y'all. And that is, of course, submitted by Kandi's attorney and everything else, and they have the certificate of service, as there was a certificate of service as well for Randy Kessler and Todd Tucker. No! You guys, I knew this was going to get messy. But like I said, it was all a scheme that Todd set up. It was all a scheme from the jump, you guys. But, none of the less, this is going to get extremely messy and everything else. And I want to know from y'all, like, what do y'all think of this? Do y'all feel for Kandi? Do you feel like she was scammed, or do you feel like she was warned multiple times by her family, specifically by Mama Joyce? Do you feel that Kandi was, again, just wanted to be married, just wanted love? She was maybe never anticipating, since she had this prenup, that Todd would come back with this? Or did you know from the start who Todd was and what Todd was about? Are you rooting for Todd to have any access to Kandi's money or any of these things? What do y'all think? And what do y'all think allegedly of Kandi requesting that things be sealed for an upcoming date in January? And I believe there is a hearing this week as well. No. But nonetheless, we knew this was going to happen, you guys. We absolutely knew this was going to happen. I want to know what happened, that the marriage is irretrievably broken. Like, what does that mean? Like, did somebody, what is that about? Did something happen? Is it financial? Is it personal? Like, what happened that it is completely broken? There is no signs of any reconciliation in any capacity. But nonetheless, you guys, I always, like I said, it was cute. Kandi filed, you know what I'm saying, on that Friday, the November 21st. And I was like, we got to wait to see what Todd says. Todd filed the day before Thanksgiving, his response, and on Wednesday. And as y'all know, everybody was closed on the holiday and everything else. And so then it comes out by Us Weekly, Todd's response. So now we're all trying to gather the receipts and everything else and talk about this. But this is crazy. This is crazy, but it should not be a shock as to how this was all going to go down and everything else. And I'm thinking, maybe Todd was thinking, if I, stretch this out to 11 years, it won't be as suspicious as what is going on and what the game plan is. But it's not a situation, you know what I'm saying, where Kandi is not able to take care of the kids. And she's basically saying, listen, look at here, like I had these full-time nannies since jump. Like, what are you talking about, daddy daycare? What are you talking about that I'm out of town all the time? You're out of town too. You know what I'm saying? So what are we doing? So this will be interesting how this is going to go. I don't know why it is mentioned that there's conversations and cooperation, because this sounds like, from Kandi's response, that she is blindsided, you guys. That she is blindsided. She wants that prenup enforced. She wants, the unseen footage, maybe the Bravo producers at that particular point in time. Like, does Carlos King need to come back in and testify on what happened with this marriage special back in 2014? Like there's so many questions, you guys. But nonetheless, that is it. That is all. Es todos, es final, es finito, es the end of the road, es the end of the line for this video. I need to hear your thoughts in the comments. Please do not forget to like, comment, and subscribe. Hit the notification bell so you're notified the moment I post a content on my channel. And with that being said, I'll talk to you guys again very soon.